Tan, please have a seat. Thank you for coming in today. My name is Nurshana binti Mansur, and here is my partner Aisha Fatima Nasruddin. So we are the handling consult for your matter.
Thank you for handling me.
Not a problem, Mr. Tan. Would you like a glass of coffee or tea?
I'll take a glass of water.
Okay, Asma?
Thank you. Alright, let's get into it. Before that, we want to explain the purpose of these initial consultations. Today, we will be listening to your account of what happened during the unfortunate scene. We will also assess the key legal elements of your situations and outlining a preliminary legal strategy.
That's right. We also want to assure you that everything discussed within this room is completely confidential and strictly protected by the lawyer-client privilege. So, as a matter of standard practice, we must discuss our fee structure up front. So, under our firm's policy, we will make this initial consultation entirely free of charge. So, if you would like us to officially take on your case moving forward, then the rate would be 100 per hour. Does that sound good to you?
That's fine with me. Let's proceed.
Okay.
Alright, now we receive the preliminary brief from our secretary regarding the unfortunate incident at the Grand Royal Hotel. Could you please walk us through exactly what took place on the evening of the event on 10 March 2024?
Well, I was attending a networking corporate gala at the hotel. I'm an important person. I'm a CEO after all, so many people want to build networking with me. I think it's around 8:05. I was in the ballroom and this massive chandelier just fell on my shoulder and my back, and I think I was told that it's like 40 kilos. Can you imagine this massive thing just fell on my back? Anyway, after that I just passed out and doesn't remember a thing.
I see. I'm sorry to hear that. It sounds like a traumatic experience. Do you remember anything else happened after the terrible impact?
It was deeply humiliating. Like I see people looking at me, screaming and like scattering around like a bird hearing a gunshot. Eventually the hotel called the ambulance and the gala was halted. I went to Pantai Hospital where I went through 5 days of these surgeries. I got discoloration in my shoulder, and look, I got 40 stitches across my face. I even got some soft tissue damages on my neck and my spine, and including even the mental damage of constant physiotherapy, PTSD, anxiety and insomnia.
I'm sorry to hear that. That must be a terrible experience to endure.
It was torture.
I understand. So, how has the Grand Royal Hotel's management responded to this matter?
You know what infuriates me the most is the fact that they're doing everything they can to dodge liability. They claim they did a maintenance check in February 2024, but keep shifting the blame to another party for manufacturing defect, I guess, for the boat. And they even delayed the apology and refused to take responsibility. I refuse to get brushed off like this. I claiming the damage. I lost so much, I think around like 2 million ringgit.
Thank you for laying that out so clearly, Mr. Tan. Now, let's address the legal landscape of your case. Based on these facts, your primary cause of action is in tort law, specifically under negligence.
Exactly. As a five-star hotel, Grand Royal Hotel owes a clear duty of care to you. They are required to ensure that the premises are safe from unusual hazards. So So, a 40 kg chandelier randomly falling in a main lobby is most likely indicating that there is a major breach of duty.
Yeah, but they defend themselves by claiming it was a unforeseeable structural defect and maintenance defect.
The res ipsa locator will be a strong tool for us. Chandelier don't just simply drop out of nowhere without someone being negligent. Hotel have physical control over the lobby, so the burden of proof will be shifted to them to prove that they weren't being negligent.
What my partner is saying is correct. In addition to that, you did mention before that you have obtained a private engineer's report stating that the bolts were corroded and improperly supported, right?
Yes, exactly.
Alright, so the result of the report directly contradicts their claim of a thoroughly monthly inspection. If the corrosion was visible, they ought to have known about it. So this third-party manufacturer's defense is weak, since the hotel has failed in its primary duty of continuous maintenance.
Right, the defense are irrelevant.
Now, let's talk about your claim of 2 millions. We will manage expectation on how Malaysian courts assess damages.
Yeah, I suffered so much loss financially, physically, and mentally.
We hear you, Mr. Tan. Let's break down that 2 million ringgits total so that we can put it in the pleadings.
Right. For the first one, my medical bills. My shoulder surgery, my 40 stitches, physiotherapy, and psychology counseling for my PTSD. That's like 150,000 ringgit. Then there's effect on my business. I lost like many foreign investors during that meeting, and the meeting itself cost us like 850,000 ringgit by missing it alone.
Understood. What about the physical and material damages, Mr. Tan?
I'm claiming 600,000 for the intense physical pain that I went through, then the reduced mobility and the sheer humiliation that I went through when I got hit by that chandelier in the gala meeting. And I also claiming 100,000 to cover my designer watch, my suit that is destroyed by the chandelier, and the transportation during the emergency time, and even my wife's hotels during the emergency situation.
And the remaining 300,000 ringgit?
That is for the blatant refusal of the responsibility. They even delay the apology. They even attempt to shift the blame to the manufacturing defect. They need to pay for that.
Thank you for laying that out. Certainly. So for your medical bills, surgery, physiotherapy, damaged designer suit, watch, and your spouse hotel stay during the hospitalization falls under special damages. So as long as we provide the receipt, these are highly recoverable.
It better be. I lost so much. Not to mention the potential investment I would have got if I did not involved in the accident.
I understand, Mr. Tan. Before we talk about that, we will talk about the general damages. This includes your physical pain, suffering, reduced mobility, and PTSD. For this one, the court will assess this based on established judicial medical tables. So the final court award might vary.
Oh, is that so?
It is so. Now, back to your previous concern, the loss of potential tech investment income. So here, you must prove a definitive loss of contractual advantage with concrete evidence or the draft agreement from those foreign investors. This means that we have to prove that you actually lost a real business deal because of the accident and not just a vague opportunity assumption.
I agree. You are asking the court for a huge amount of money, so the judge won't simply take your word for it. So you need to show a solid proof that the deal was guaranteed practically.
Solid evidence.
Yes, maybe a draft contract or witness statements. Otherwise, the court will dismiss the claim as too speculative.
Okay, I understand for that. But what about the part where hotel ignorance in not acknowledging their liability?
Well, their poor attitude and delayed apology will be argued as damages due to their excessive conduct.
Okay, I understand, but what we need to do now?
Well, we will formally compile your medical reports, the private engineer's reports, receipts for your disrupted damaged items, and any other corporate documentation that shows disrupted investor meetings, Mr. Tan.
I second to that. Once we have fully categorized, we will draft and issue a formal MOD to the hotel management. Here, we will give them a strict timeline to respond or to settle. If they maintain their denial of liability, we will fully prepare to file a civil suit in court.
Do not give them too much time because, I'm in school.
I understand, Mr. Tan. We will keep you informed and updated every single step of the process. Thank you for trusting us for your case.
That's fine with that. A little book told me that you guys are the best firm in town, so I think you guys can handle it. Bye.
Wow, Mr. Tan is certainly a character. What, a little book told him that we are the best in town? No pressure at all.
Yeah, tell me about it. But ego aside, he has a solid prima facie case in negligence. Let's look at the merits. Can he win this if it goes to court?
I'd say his chances on liability are exceptionally high. The res ipsa loquitur doctrine sides on his case. So the chandeliers do not just drop from five-star hotel ceilings without a structural breach of duty. Plus, that private engineer's report shows visible corrosion that completely neutralizes the hotel's defense of a unforeseeable structural defect. So, under the laws of occupiers' liability, they owed him a duty as an invitee and failed miserably.
Agree. Liability is a slam down, but his quantum of damages is where we are going to face uphill battle. Here, he is demanding 2 million ringgits. The special damages for medical bills and ruined property are straightforward because they are easily quantifiable with receipt. But that RM 850,000 ringgit claim for lost investment.
Exactly. If we cannot provide solid proof, like documentary proof, like signed letter of intent or a concrete draft agreements, the court will throw it out for sure for being like too emotive and speculative. So Malaysian courts do not award millions based on a vague assumption. So that 300,000 ringgit for the hotel's bad attitude. Aggravated damages are highly discreet, and courts rarely award such delayed apology.
Which bring us to our choice of forum. Should we push for court litigation or advise him through alternative dispute resolution ADR, like mediation or arbitration?
Honestly, mediation is the absolute best outcome for both sides.
Well, I think so too. Why do you prefer mediation over arbitration or trial?
Well, arbitration is essentially a private litigation, right? So it is still adversarial, it is expensive and takes time. But a full court trial will drag out for months, if not years, which violates Mr. Tan's strict demand that time is gold. So more importantly, the hotel wants to protect its five-star reputation from terrible press, and Mr. Tan wants a quick payout without having his business financials intensely cross-examined in an open court. So mediation allows for a confidential win-win settlement between the two where we can compromise a, let's say, a realistic quantum, say 1.2 million instead of his inflated 2 million.
Spoken like a true handling concern, mediation it is. Okay. Under Order 34 of the Rules of the Code 2012. Here we can request a judge-led mediations at the pre-trial stage anyway, but let's try to initiate private mediation first, I think.
Perfect. Let's divide the labor. So, who is going to contact the hotel's legal representatives and organize our client's massive pile of documents?
I think I can take charge of compiling the evidence and onboard the documents. I will sort through his Pantai Hospital medical files, the psychiatric evaluation for his PTSD, the receipt for his designer suit and watch, and also the private engineer's report. I will also will draft the formal letter LOD outlining our intention to seek mediation, I guess.
Okay, then I will handle external communications. So I will reach out to the plaintiff side or rather the defendant hotel's panels, lawyers, once they respond to our initial brief. So to test the waters for an amicable out-of-court settlement, I'll also schedule a meeting with Mr. Tan's corporate secretary to extract any non-speculative, financial evidence regarding those foreign investors, so we can actually have leverage during this negotiation.
Sounds like a plan. Let's get to work before Mr. Tan calls us for demanding the updates.